Hey everyone, this is Angela, and we're back for another episode of Study for the Bar in Your Car. So this is the podcast where we use AI technology to help us study for the bar exam. And we're studying for this bar exam in passive time. So when you listen to these podcasts, this isn't your main study plan. These podcasts, it's like filler information. It's when you want to study, but you're sort of between doing active stuff. So you're in your car, or maybe you're cooking dinner, or maybe you're in the shower, or you're on an airplane. You know, this is when you're not doing your active studying. It's filler time. So one thing you should remember, AI isn't always correct, but I do try to make corrections when I hear something that's not right. Number two, I'm not an attorney. I am a law student just like you. I have literally just put my own notes in AI, and AI has given me this fantastic podcast. So we have our two AI hosts. I've named them Claude and Maud, and they take my notes, they digest them, and they create this dialogue between them. And my notes, when two people are speaking it, are so much more like interesting than just reading it alone. So that's why I like this podcast. My voice is creaking, and I don't know why. That's so weird. Anyhow, so this is episode 12 of contracts, third parties. After episode 12, we have episode 13, which is our bar exam tips, and then episode 14, where we wrap up contracts. But for episode 12, third parties, we are going to focus on third-party beneficiaries, assignment of rights, delegation of duties, and we're going to define what the third parties are. And maybe we'll have some bar exam tips for third-party beneficiaries as well. Anyhow, I pay for this podcast myself. I don't ask for donations or anything. But what I do ask is that if you are an attorney or you know an attorney who needs freelance, ad hoc, remote law clerk support, call on me. I'm a law clerk. I work with attorneys across the US and sometimes also in the UK because I'm a dual citizen. And I am a ghostwriter basically for attorneys for appeals, briefs, complaints, answers, letters to DAs, etc. You can reach me for law work at hello@legalwriterandlawclerk.com. And if you want to talk to me about the podcast, you can reach me at podcast@studyforthebarinyourcar.com. And we have listeners from all around the world. I looked at the stats, and I'll say they're modest at this point, but we have people checking in from France, Zimbabwe, England, the United Kingdom. I don't know if it's England. It could be Scottish, Northern Irish, or Welsh, or maybe Isle of Man. I don't know. We also have people coming in from France. So like a few places. Oh, also Korea. So I'm excited about that. So yeah, this podcast is growing slowly, very slowly, but hopefully it'll pick up. And I think, for most podcasts, it takes about 3 months to get some traction. So maybe by the time you're listening to this, we would have blown up a bit more. Anyhow, so without further ado, here are our AI hosts, Claude and Maud. Take it away, guys.
Welcome to this deep dive, crafted to help you really get a handle on some key legal concepts for the bar.
Yeah, welcome.
Today, we're digging into third-party beneficiaries and also the assignment of rights and delegation of duties through contract. And we're using some great law school notes as our guide, thanks to Angela from the Study for the Bar in Your Car podcast for those.
Absolutely. These notes are fantastic. Our job today is basically to unpack these complex topics from Angela's outlines, zeroing in on what you really need to know for the bar exam.
Exactly. More than just definitions, we want to get into the why behind the rules.
Right. Help you think through those tricky fact patterns.
Okay, so let's kick things off with third-party beneficiaries. According to Angela's notes, what's the basic setup here?
Well, think of it like this. You've got Party A, who makes a valid contract with Party B.
Standard contract so far.
Right. But part of their deal is that party B needs to do something, perform some service, or pay some money directly for party C.
And party C wasn't involved in making the original deal.
Exactly. C is the third party. So A is the promisee, B is the promiser, the one making the promise to perform for C, and C is the beneficiary.
Got it. But Angela's notes probably emphasize that not just anyone who happens to benefit from a contract gets legal rights, right?
Oh, absolutely. That's maybe the most crucial point. Angela's outlines stress that it all comes down to the intent of the original parties, A and B.
Intent. Why is that so central?
Well, contract law is mostly about enforcing agreements people actually make. Giving rights to a third party is kind of an exception.
Ah, I see. So the law needs a good reason.
Precisely. It needs clear evidence that A and B intended for C to have the right to enforce that promise. Only intended beneficiaries can actually sue if B doesn't perform.
Okay, so if they're not intended beneficiaries, what are they called in Angela's notes?
They're called incidental beneficiaries. Angela's materials make this distinction very clear.
Incidental, meaning?
Meaning they might benefit, maybe indirectly, from the contract being performed, but that wasn't the core purpose of the deal between A and B.
And these incidental beneficiaries, they can't sue.
Nope. Angela's notes state they have no legal standing to enforce the contract. No rights.
Okay, so focusing on the intended ones, does Angela break those down further? Are there different types?
Yes, her outlines almost certainly do. There are two main types you need to know for the exam.
Okay.
Done beneficiaries and creditor beneficiaries.
Done and creditor. Let's tackle done first. What defines a done beneficiary according to her notes?
A done beneficiary is someone who gets the benefit as a gift. Party A, the promisee, is basically using the contract with B to give something to C. Think life insurance. The insured pays premiums, so the insurer promises to pay the beneficiary upon death. That beneficiary is usually a done.
Okay, like a gift through a contract. What about their rights against the person arranging the gift, party A?
Generally, Angela's notes would point out that a done beneficiary cannot sue the promisee, A, if the promiser, B, fails to deliver.
Why not?
Because, well, there's usually no legal right to force someone to complete a promised gift. It wasn't based on a pre-existing obligation from A to C.
Right, that tracks with gift law principles. Okay, now the other type, creditor beneficiary. What's the story there in Angela's outlines?
The creditor beneficiary is different. Here, the promisee, party A, already owes some debt or obligation to the third party, C.
Ah, okay, a pre-existing debt.
Exactly. And the contract between A and B is set up so that B's performance will satisfy the debt A owes to C. B is essentially paying off A's debt to C.
So it's not a gift, it's fulfilling an obligation. Does that change C's rights, especially against A?
It does. Angela's notes would state that a creditor beneficiary can sue the promisee, A, on that original underlying debt if the promiser, B, fails to perform.
So they have two potential people to go after, B on the new contract and A on the old debt.
Basically, yes. They have recourse back to the original obligation.
Okay, this distinction feels really important for exam questions. What's the core advice from Angela's notes for tackling these scenarios on the bar?
The main bar exam tip from Angela's notes is laser focus on the original contract and the intent of A and B. You have to ask, who were they trying to benefit directly with this specific performance?
And then classify based on the purpose.
Right. Was the primary purpose to give a gift? That points to Dunny. Or was it primarily to satisfy a debt A already owed? That points to creditor. Analyzing that purpose is key.
What about problems with the original A-B contract itself, like, say, fraud or lack of consideration? Can B use those defenses against C, the beneficiary?
Yes, absolutely. Angela's notes highlight this. The intended beneficiary's rights aren't bulletproof. They're subject to any defenses the promiser, B, could have raised against the promisee, A.
So C basically steps into A's shoes regarding B's defenses on that specific promise.
That's a good way to think about it. The stream can't rise higher than its source, so to speak. If the promise wasn't enforceable between A and B, it generally won't be enforceable by C either.
Okay. Now, what about changes? Can A and B just change their minds and modify the contract to cut C out? Angela's materials probably talk about vesting of rights. What does that mean?
Yeah, vesting is crucial. As Angela's notes likely explained, vesting is the point in time when the third party's rights become locked in, essentially.
Locked in how?
Meaning A and B can no longer change or cancel the contract in a way that harms C's benefit, unless C agrees to it.
Okay. So when does that happen? When do the rights vest?
Well, Angela's notes might list a few common triggers. It could be when C learns about the contract and manifests assent to it, like saying, okay, great.
Right.
Or when C materially changes their position in justifiable reliance on the promise, like maybe they took out a loan expecting the payment.
Makes sense. Reliance is often key in contracts.
And sometimes vesting occurs when C actually files a lawsuit to enforce the promise. The exact rules can vary slightly, but those are the main ways.
Got it. So once vested, C's rights are protected from A and B, tinkering with the deal. All right, that feels like a solid overview of third-party beneficiaries thanks to Angela's outlines. Let's switch gears now. Assignment of rights. What are we talking about here according to her note?
Okay, assignment. Angela's notes would define assignment as transferring your rights under a contract to someone else.
Transferring the benefits, essentially.
Precisely. The original party giving up the right is the assignor. The third party receiving the right is the assignee. And the original party who still owes the performance is the obligor.
Assignor gives, assignee receives, obligor owes, now to the assignee.
You got it.
So can you just assign any contract right you have? Are there limits? What would Angela's outlines say?
Generally, yes, most contract rights are assignable. But Angela's notes would definitely point out exceptions.
Like what?
Well, you usually can't assign a right if doing so would fundamentally change the obligor's duty or increase their risk significantly. Think of a personal service contract. If you hired a specific artist to paint your portrait, that artist probably can't just assign the right to payment before they paint because your duty to pay is tied to their specific performance. Or, more clearly, you hire someone to provide personal security. They can't just assign the duty to someone else if you relied on their specific skills. Oh wait, that's delegation for assignment rights. Think maybe a requirements contract. If assigning the right to purchase goods would drastically change the quantity the obligor has to provide, that might be barred.
Okay, that makes sense. What else?
Also, if the original contract itself has a clause saying no assignment of rights, that's usually enforced.
Anti-assignment clauses.
Right. And finally, some assignments are prohibited by law or public policy, like you typically can't assign future wages in some jurisdictions.
Okay, so right to receive money is usually assignable, personal services less so.
Generally, yeah. The right to payment is the classic assignable right.
Angela's notes might also talk about assignments given for free versus those paid for, gratuitous versus for consideration.
Yes, definitely. A gratuitous assignment is just a gift of the right. No payment or value given back to the assignor.
And the other.
An assignment for consideration is where the assignee gives something of value, money, services, whatever, in exchange for the right.
And why does this distinction matter? Revocability.
Exactly. As Angela's notes probably highlight, gratuitous assignments are generally revocable by the assignor. They can change their mind.
How?
Well, the assignor could just tell the assignee or the obligor, hey, I revoke. Or they could accept the payment themselves from the obligor. Or even assign the same right to someone else later.
He's fragile. Is there any way to make a gift assignment stick?
There is an exception. Angela's notes might mention the token shows delivery. If the assignor gives the assignee something symbolic that represents the right, like maybe the physical written contract itself or a savings account passbook, that physical delivery can make the gratuitous assignment irrevocable.
Interesting little detail. And assignments for consideration.
Those are generally irrevocable. Once value is given, the assignor can't just take the right back.
Okay. So, assuming we have a valid irrevocable assignment, what's the relationship now between the assignee and the obligor? What rights does the assignee have according to Angela's notes?
Angela's notes would be clear. The assignee now stands in the shoes of the assignor. They are the real party in interest and can sue the obligor directly to enforce the right.
But what about defenses? Does the obligor lose defenses they had against the original assignor?
No, and this is super important for exams. Angela's outlines will stress that the assignee takes the right subject to most defenses the obligor had against the assignor that arose before the obligor got notice of the assignment.
Okay, so the assignee isn't better off than the assignor was regarding those existing defenses. Can you walk us through that Opie Andy Laurie example from Angela's notes?
Sure. So imagine Opie owes Andy $200. But maybe Andy previously did some bad work for Opie, causing $50 in damages, and they agreed Andy owes Opie that $50. So there's a $50 set-off Opie has against Andy.
Okay.
Now, Andy assigns his right to the $200 payment to Laurie. Before Opie learns about this assignment, the $50 set-off already exists.
Right.
So when Laurie comes to collect the $200 from Opie, Opie can say, wait, I only owe $150 because Andy owed me $50. That defense Opie had against Andy is valid against Lori, the assignee.
Because it arose before Opie got notice of the assignment to Lori.
Exactly. Timing of notice is key.
But Angela's notes mention an exception, right? What about defenses that pop up after the obligor gets notice?
Right. This is a crucial distinction. Angela's outlines would likely explain that personal defenses like set-offs or counterclaims that arise after the obligor has noticed the assignment generally cannot be asserted against the assignee.
So in that example, if Andy damaged Opie's fence after Opie already knew the right to payment belonged to Lori,
then Opie probably couldn't use that new $50 claim to reduce what he owes Lori. He'd have to pursue Andy separately for that damage. Notice cuts off most later defenses against the assignee.
Okay, notice is really the linchpin there. What if the original parties, the obligor and assignor, try to change the contract after the assignment?
Good question. Angela's notes likely cover this. Modifications made before the obligor gets notice of the assignment. Those usually bind the assignee too. They take the contract as modified.
But after notice?
After the obligor gets notice, Angela's materials probably state that modifications between the obligor and the assignor generally don't affect the assignee's rights, even if they act in good faith. The assignee's right is based on the contract as it stood when notice was given.
Protects the assignee's expectation. What if someone is, well, dishonest or just disorganized and assigns the same right to two different people? Successive assignments, Angela's outlines touch on that.
Yeah, her notes might briefly mention this tricky area. The rules can differ, but a common rule, sometimes called the American rule, is that the first assignee for consideration generally wins.
First in time, first in right, if they paid for it.
Kind of, but there are exceptions. Like, a later assignee might win if they, without knowing about the first assignment, actually get payment from the obligor or win a lawsuit or get a novation. It can get complicated. The English rule gives priority to the first assignee to give notice to the obligor. You'd need to check jurisdictional rules.
Okay, good to know it's complex. So, we've covered rights. Let's flip to the other side. Delegation of duties. What's the core idea there based on Angela's notes?
Right, delegation. Angela's notes would explain this is about transferring the obligation to perform.
The duty. Not the benefit, but the work.
Exactly. The party who originally owed the duty is the delegator. The party who agrees to perform the duty is the delegate. And the party who is owed the performance is still the obligor.
Delegator transfers the duty to the delegate. Obligee still expects performance. Can any duty be delegated?
Not quite. Angela's materials likely explain that most duties are delegable, unless the performance relies on the unique personal skill, judgment, or talents of the original obligor.
Like the portrait painter example again.
Yes, exactly. If you hired a specific, famous architect, they probably can't just delegate the design work to a junior associate if your contract was based on their personal reputation and skill.
Makes sense. Any other restrictions?
Also, if the contract itself prohibits delegation and anti-delegation clause, then you can't delegate.
Okay. Now, here's the million-dollar question. If I delegate my duty, say, to paint a house to someone else, and they do a terrible job or just don't show up, am I off the hook? What do Angela's notes say about liability?
Definitely not off the hook. This is fundamental. Angela's notes will strongly emphasize that the original obligor, the delegator, remains liable to the obligee if the delegate fails to perform properly.
So delegation doesn't extinguish my original responsibility?
No. Think of it like this. You can delegate the performance, but you generally can't delegate the liability just by asking someone else to do the work. The obligee's original deal was with you.
Unless. Is there a way to get fully released? Angela's notes mention novation as an exception.
Yes. Novation is the way out. Angela's notes would define a novation as a three-way agreement.
Three-way.
Meaning the original obligor, delegator, the obligee, and the new delegate all have to agree. The obligee must explicitly agree to release the original obligor from their duty and accept the delegate as a full substitute.
So the obligee has to say, okay, original guy, you're out. New guy, you're in, and I'll look only to you now.
That's basically it. If you have a valid novation, the original obligor's duty is completely discharged. It's a true substitution, not just a delegation of performance.
Got it. Delegation keeps you liable. Novation gets you out, but requires everyone's agreement.
You've nailed it.
All right, well, that seems to wrap up our deep dive into third-party beneficiaries, assignment of rights, and delegation of duties, drawing heavily on those excellent law school notes from Angela.
Yeah, we covered a lot of ground, from intent being key for beneficiaries to the rules around assignment and notice and that crucial liability point with delegation versus novation.
Hopefully, breaking it down like this, using Angela's framework, gives you, our listeners, some real clarity for your bar prep. Remember those key distinctions.
Absolutely. Focus on intent for third parties. Understand what makes a right assignable or a duty delegable. And always track who had notice of what and when, especially in assignment problems.
So maybe as you keep studying, think about this. How would you spot language in a contract that intends to create third-party rights versus just having an incidental effect? Or what specific phrasing signals a valid anti-assignment clause?
Good questions to ponder. Applying these concepts is the next step. And hey, if there are other thorny contract law areas you're wrestling with, let us know. Maybe we'll tackle them in our next deep dive.
Hey, this is Angela again, and I hope you enjoyed third parties in contract law. And we are slowly coming to the end of contract law. We have got 2 more contract law podcasts coming up. We've got the next episode, which is bar exam tips. So this is specialized tips just for handling contracts on the bar exam. And then after that, we have a contract law wrap-up where we will close down contract law. And we will look forward to the next topic, which is evidence. And for evidence, we have the podcasts are they're changing a bit because the software has changed. So in the middle of, or at the end of doing these contract podcasts, Google, so I use Notebook LM for these podcasts, Google updated the software, and I've been able to prompt the Maud and Claude in ways that I couldn't have done before, because now they've given me more characters to do so. So for evidence, I'm going to take a slight leave of absence, so you'll just hear from them. And I want to see how that goes. Maybe you'll miss me, maybe you won't, but I'm going to let them hold the floor for that. But I'll be back, don't worry, I'm not leaving forever. Anyhow, thank you for tuning in. Just a few housekeeping things. 1, I'm not an attorney. Nothing in this should be construed as legal advice. 2, I am just a student just like you. AI isn't always correct, but I really try to make corrections. If there's something I hear that's incorrect, I'll go back and I'll redo the whole podcast. So it won't be edited. It will be like just a whole new episode. But you won't know if it's, sometimes I'm on my second or third iteration of an episode. And for you, it'll sound like the first one, but I know that it's like the third or fourth or whatever. Be safe when you're driving. So if evidence law is going to make your blood boil, maybe don't study for the bar in your car. Maybe, study for the bar in the shower, or study for the bar on an airplane or whatever. So if you need to reach me regarding this podcast, you can reach me at podcast@studyforthebarinyourcar.com. If you would like to reach me regarding legal work, remember, I am a freelance law clerk. So if you are an attorney or you know an attorney who needs freelance ad hoc remote law clerk work, you can reach me at hello@legalwriterandlawclerk.com. All right, that's going to be it for now. I will see you on the next podcast where we go over bar exam tips. Bye.